Thanks a lot, Ernie. Ernie, though I'm a bit suspicious, when the administrative director of the Center for Global Justice, Human Rights, and the Rule of Law asked the executive director of the Center for Global Justice and Human Rights and the Rule of Law to speak against human rights, I think there might be a coup or something in the works here. But I fell for it, sort of. So what is this threat or menace? Actually, my thesis is that this thing is both threat and menace, so you don't have to parse the difference between the two. Positive human rights are known often as second-generation rights. So to understand second-generation rights, let's take a look at the first generation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Words that I think you could take as according more or less with Genesis 9:6, the description of the ministry of civil government. But for our purpose, let's look at the form of the inalienable rights, or unalienable rights. I think Jefferson had written inalienable, and it had been changed to unalienable by the printer. We'll call them inalienable rights. What's their form? What do they demand of others? It looks like the form of these rights are that others not improperly interfere or deprive people of the object of the rights. So the inalienable right to life is the right that we hold that others not inappropriately take our lives, unlawfully take our lives. It negates the powers of others to do something with our rights. The nature of these rights is, in that sense, negative. It means that others don't have the power to take the object of the right from us. And civil government is said to secure these rights. Does the language I just read indicate that we have a right against civil government, that they secure our rights? No language like that. There's no language that says we have a right to claim against civil government, that they positively protect our rights. Instead we have a right in the people to alter or abolish the civil government if it doesn't do its job. So, and that, again, is a negative right. It's a right we assert to change the civil government. Others should not unlawfully interfere with that. So notice, it seems that there are negative rights in play here and a conspicuous absence of a positive right. And I'll explain further what that means. But there's no right against government that they protect your life. There's a right to life. There's a right to change government if civil government fails in its object. But there's no mention of a right that we have against the government to protect our rights. Seems, again, negative rights. Or take, for example, the Bill of Rights. Congress shall make no law. The right of a people to keep and bear arms shall not be infringed. No soldier shall in time of peace be quartered, nor in time of war but in manner prescribed by law. The right of a people to be secure in their persons, houses, etc. shall not be violated. No warrants shall issue. Amendment 5, no person shall be held to answer, nor shall be compelled to be a witness against himself, nor deprived of life, liberty, or property, nor shall private property be taken. Skipping to Amendment 8, excessive bail shall not be required. The form of these rights. Again, it seems that universally the form of these rights is that the federal government has no power to exercise to take away the rights that are declared. It's a negative right, and these are negative rights. They negate the power of federal government to deprive people of certain rights, the objects of certain rights. Well, I omitted in my abbreviated recitation Amendment 6, Amendment 7. Amendment 6 says the accused shall enjoy the right to a speedy and public trial by an impartial jury, and to be informed of the nature and cause of accusation, to be confronted, to have compulsory process, to have assistance of counsel. Amendment 7, likewise, the right of trial by jury shall be preserved. Are these positive rights? Are these rights whereby we claim the federal government must supply certain things? It may seem so, except I left out in my reading the beginning of those amendments. The beginning of Amendment 6 is, in all criminal prosecutions, the accused shall enjoy the right, which seems to make it a negative right. If you're going to be prosecuted, if the federal government prosecutes you, then there are certain rights that the defendant enjoys, so they are sort of conditional negative rights. The government would fulfill this obligation by not prosecuting anyone at all. But if it does prosecute people, there are certain rights it must respect. Likewise with Amendment 7. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury. Again, a negative right, because there's no reason why the federal government should make you subject to civil suit at all if it's not going to fulfill its obligation to give you a trial by jury. So even these rights that may appear partially to be rights other than negative rights are really conditional negative rights. They negate the power of the federal government to put you on trial as a defendant, civil or criminal, without fulfilling certain obligations. Let me propose to you that there is a test, a handy test, in deciding whether a right against civil government is negative or positive. Let me propose this. A right against civil government is negative if it automatically would be satisfied were that civil government not to exist. So think about it. If the federal government didn't exist at all, it's already satisfying, in a sense, your right to a trial. It's already satisfying the right you have to compel witnesses, because it's not putting you on trial at all. It's not doing those things. So I think that these rights, all the rights in the Bill of Rights, are best understood as negative rights. What's the relationship between the inalienable rights of the Declaration and these negative rights? Well, let me suggest that in one respect, these negative rights regulate civil government, specifically the federal government, as it secures inalienable rights. And to some degree, it actually assures that the civil government not violate inalienable rights as it secures inalienable rights. So there is this supportive role that negative rights bear with respect to inalienable rights of the Declaration of Independence. The Bill of Rights is linked to another concept that is central to my thesis, and that is the rule of law. And the rule of law is best understood through thick and thin, one might say. That is, there's a thick notion of the rule of law and there's a thin notion of the rule of law. And the first theorist of the rule of law, Aristotle, mentions both of these in his famous discussion of the rule of law. These two senses are these. One sense of the rule of law means obedience to such laws as have been enacted, and another, which means the laws obeyed have also been well enacted. The first sense is the thin sense. The second sense is the thick sense. The thin sense can be understood this way. It requires a civil government to act under rules that are fixed, announced beforehand, applied generally, with institutions to enforce the law effectively. That's the thin notion, one understanding of the thin notion of the rule of law. The thick notion thickens this by adding to this thin requirement elements of justice, elements of human rights, let's say, requirement that there be democratic process. So the thick builds upon the thin. But most folks would agree that however thick you make the rule of law concept, the thin is a sine qua non. The thin is a necessary minimum to the notion of the rule of law. And so if the thin notion of the rule of law is threatened in any regime, the rule of law is threatened. However thick you might make the notion, if the thin is not there, then the rule of law itself is compromised. What's the link between the inalienable rights of the Declaration of Independence and the rule of law? Well, you could say that the Declaration, the negative rights there, preserve rights from lawless deprivation. That might suggest a role with respect to the rule of law. And also think especially of liberty. How much liberty can be exercised if the rules under which you exercise that liberty change all the time? How can you exercise a liberty to contract, let's say, if the rules of contract change 2 days later arbitrarily? It's kind of hard to see that as being authentic, full-blooded exercise of liberty. Liberty for choices not to be frustrated by ad hoc alteration of the consequences of our choices, the rule of law serves that role. It preserves meaningful choice. It preserves a stable platform within which we exercise our choices, liberty. So there's that link as well. The link to the Bill of Rights. Well, the Bill of Rights supports the rule of law specifically, Fifth Amendment, Sixth Amendment, Seventh Amendment, with these procedural rights requiring the civil government to adhere to its own rules, particular rules. But it also, and maybe this is even more important, it presupposes the rule of law. What good is a Bill of Rights laying out rules if those rules are not binding on the civil government? The civil government could change the rules under which it operates. So the Bill of Rights both endorses and supports the rule of law, but it also presupposes the rule of law. In a sense, these negative rights and the rule of law are mutually reinforcing. They're mutually supportive. Enough on the rule of law in general and negative rights. Let's turn to something different. I'll be reading excerpts from 3 documents. The first document is the Universal Declaration of Human Rights of 1948, Article 22. And these are just excerpts again. Everyone, as a member of society, has the right to Social Security and is entitled to realization of the economic, social, and cultural rights indispensable for his dignity and the free development of his personality. Article 23, everyone has the right to work, to free choice of employment, to just and favorable conditions of work, and to protection against unemployment. Everyone who works has the right to just and favorable remuneration, ensuring for himself and his family an existence worthy of human dignity and supplemented, if necessary, by other means of social protection. Article 24, everyone has the right to rest and leisure, including reasonable limitation of working hours and periodic holidays without pay. I think I need to invoke that more than I do. Article 25, you too, maybe. Article 25, everyone has the right to a standard of living adequate for the health and well-being of himself and his family, including food, clothing, housing, and medical care, and necessary social services, and the right to security in the event of unemployment, sickness, disability, widowhood, old age, or other lack of livelihood in circumstances beyond his control. Article 26, everyone has a right to education. Technical and professional education shall be made generally available, and higher education shall be equally accessible to all on the basis of merit. Now this document, the Universal Declaration of Human Rights, is professedly aspirational. It's not a legally binding norm upon any government. It's merely supposed to be a guide to inspire civil governments to provide these things. But query, is it really good for these rights to be recognized by civil governments at all? It's something that would be incumbent upon them. Next document, the International Covenant on Economic, Social, and Cultural Rights. This is binding upon its signatories. The United States is not one, however. Some provisions from this covenant. Again, excerpts only. Article 6. The states parties to the present covenant recognize the right to work, which includes the right of everyone to the opportunity to gain his living by work, which he freely chooses or accepts, and will take appropriate steps to safeguard this right. Article 9. The states parties to the present covenant recognize the right of everyone to Social Security, including social insurance. Article 11. The states parties to the present covenant recognize the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. Article 12. The states parties to the present covenant recognize the right of everyone to the enjoyment of the highest attainable standard of physical and mental health, and the steps incumbent upon signatories include those necessary for the creation of conditions which would assure to all medical service and medical attention in the event of sickness. Article 13. States parties to the present covenant recognize the right of everyone to education. They agree that education shall be directed to the full development of the human personality and the sense of its dignity, and shall strengthen the respect for human rights and fundamental freedoms. Now, these norms are legally binding on signatories, but there are general articles in the beginning which maybe should give us pause. These articles seem to compromise or qualify or make derogable certain of these obligations. For example, Article 2, first part. Each state to the present covenant undertakes to take steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means, including particularly the adoption of legislative measures. And then Article 4, The states parties to the present covenant recognize that in the enjoyment of those rights provided by the state in conformity with the present covenant, the state may subject such rights only to such limitations as are determined by law, only insofar as this may be compatible with the nature of these rights, and solely for the purpose of promoting the general welfare in a democratic society. Again, my suggestion to you is, doesn't give one pause to think that these grand rights are made explicitly subject to qualifications, to diminution. What would be the case if negative rights were subject to the same limitations? Is there some danger, perhaps, in recognizing these full-blooded, full-throated positive rights, and at the same time saying, but if the state has good reason to depart from them, so be it, perhaps? The last document, and in this document, these legally binding obligations are not derogable, they're not qualified, they're not compromised, and some writers are very proud of the fact. I'm reading from the African Charter on Human and People's Rights, and these, again, are binding on the subscribers. I think all the African nations but for South Sudan has subscribed to this, last I looked. And again, excerpts. Every individual shall have the right to work under equitable and satisfactory conditions and shall receive equal pay for equal work. Every individual shall have the right to enjoy the best attainable state of physical and mental health. States parties to the present charter shall take necessary measures to protect the health of their people and to ensure that they receive medical attention when they are sick. Article 17, every individual shall have the right to education. From these examples, see how different these rights are from negative rights. See how they make a positive claim on civil government to provide certain things, not simply to refrain from action, but to positively to act, to supply the object of these rights. That's why they're called positive rights as opposed to negative rights. And it is these grand positive human rights that I think are the threat and menace. The nub of the matter really is similar to a question that St. John Paul II discussed in his encyclical Veritatis Splendor, section 67. And there he makes a distinction, well-founded distinction, traditional distinction, between negative moral precepts and positive moral precepts. And analogous to negative moral precepts would be negative duties, and analogous to those are negative rights. And analogous to positive moral precepts are positive moral duties, which are analogous to positive rights. He says negative rights are, in their nature, categorical, peremptory. They're not susceptible to qualification. Once you know the range of what this moral precept is, that precept applies absolutely. It's not to be departed from, not to be compromised. But with respect to positive moral precepts, it's very different. Think about this. We are to love our neighbor as ourselves. How is that to be expressed? Do I take my immediate neighbor under my wing and evangelize him and minister to him? Or do I spend my time instead on weekends going to work with the PIN ministry at the beach helping homeless folks? How do I fulfill my positive obligation to love my neighbor? We know that we're neighbors. We're to act as neighbor to everyone. Well, how do we do this? How many do we feed? Do we clothe one person really well? Or do we clothe a lot of people in part? Do I give my money to a particular person, or I instead give part of it to World Vision, part of it to Compassion? You see that? It requires, as John Paul said, prudence. Fulfilling positive moral precepts and positive moral duties, that is, satisfying maybe positive rights, requires prudential judgment. It's inherently contextualized, inherently qualified. And I think you can see evidence of this from the Scripture, Exodus 21, 22, and 23, where the Scriptures make pretty clear that it is negative rights that are civilly enforced in Israel. Positive rights generally are not civilly enforced in Israel. Israel, of course, I mean the Old Testament, the Mosaic Law, the Old Testament regime. And that when positive rights are enforced civilly, they are specified, they are triggered by a certain event, they're clarified and particularized. So I think the Scriptures support the notion that there's a big difference between negative moral precepts, negative duties, negative rights, and positive moral precepts, positive duties, positive rights. What happens then if a civil government does recognize general positive human rights? What consequences could be anticipated? And what consequences, in fact, have been documented to a large degree? First, positive rights appear to guarantee results Food shall be supplied. Clothing shall be supplied. Education shall be supplied. It requires civil government to supply certain goods. Often this is impossible or impracticable, especially in East Africa where there are impediments to doing it. And so in those situations, rights end up not being respected as binding norms. They're seen just as paper. They're really not taken seriously. Once rights can be seen in some measure as impracticable, what's to keep negative rights from being seen in certain circumstances as impracticable, too expensive? Second, positive rights, as I've just discussed, demand contextualization, qualification. They're not peremptory entitlements, categorical trumps. But this notion is necessary to negative rights. Negative rights would really be ineffective if the civil government could, in certain cases, say, well, that negative right doesn't apply in this particular case given the context. How strong will rights be once they become susceptible to contextualization, qualification? And again, there might be some attempt to isolate positive rights and treat them differently, but my suggestion is once you say rights themselves inherently can be subject to contextualization, it really invites that move even with respect to negative rights. Also, positive rights are frequently translated or transformed into something less than they promise. So, for example, the right to medical care, I think this is in South Africa, has been translated to the right to wait in line for medical care. Or the right to food has been translated into the right to have civil government perform studies about food, or plan for food supply, or monitor the food supply. The rights mean something other than they purport to mean. And again, is this not a danger for rights generally? If we can treat some rights this way, what's to say we can't treat other rights this way, including negative rights? Fundamentally, to embrace these grand positive human rights, I think transfers rights into interests. They become just factors. They become things to be taken into account. They don't become categorical rules regarding what the state can do, must do, should do. So it deflates rights really from law into politics, ends up turning it into politics, becoming sham human rights, I'd suggest. And this would threaten all negative rights and menace all negative rights with deleterious consequences for inalienable rights, I think. So much for the effect on recognizing positive human rights, the effect on negative human rights. What about the effect on the rule of law? Well, I think similar consequences bode similar results with respect to the rule of law. For example, positive rights requiring results, guaranteeing results, thinking of food, housing, medical care. How do we reduce these rights to results to conduct, rules of conduct to hold the civil government accountable? How is that effectively done when there's no necessary connection between conduct and result? Think of the right to have food. Well, you can say, okay, government, supply food, but what if there are disruptions in food supply? What if there is famine? What if there are other external events? Wouldn't that excuse the government? Perhaps. It's hard to prescribe exactly rules of conduct to which you can hold the civil government accountable if you're looking instead at results and not conduct. How about the contextualization? Positive rights being matters of degree, balancing, contingencies, considering the fisc, considering the budget. By what rules are all these contingencies to be taken into account? Really, you'd ask, based on what John Paul said about positive moral precepts requiring prudence, how does one reduce prudence to rules? How can one have the rule of law when we're really enforcing prudential decisions and not rules? Third, again, this translation, this transformation. By what rule of law does one translate a grand human right into something less? How is that observing the rule of law, this translation process? And once translated, how do we use rules to test whether the process, the programs that are the translation are actually fulfilling their promise? For example, there's a commentator who says the positive right to X, let's say, is really the positive right to providing a court as a forum for telling stories about the need for X and how X is not being supplied. It's to provide a forum for discourse in order to promote progress towards X, So the right to food is really the right to go to court, to tell a story about lack of food, to enter into a discourse in the court about the need for food and how the civil government's not supplying it. That's what the right to food ends up being. And again, by what application of the rule of law can we transform the right to food into something like this? And then once you do translate it into that, how do you use the rule of law, rules, to test whether that right is being fulfilled, transformed as it is? And again, I would suggest positive rights becoming interests, become interests among a multitude of competing, conflicting interests, a diverse weight, diverse value, diverse expense. By what rule does a court accommodate these interests? It's hard enough for interests, let's say a bilateral dispute of interest, to be adjudicated. But when you have these multifaceted, this web of interests, how is a court applying rules, which are part of the rule of law, to be subject to rules, generally applicable rules? How does that work when the courts are accommodating these multifarious interests? So I'd suggest positive rights, these grand human positive rights, threaten or menace the rule of law with deleterious effects for inalienable rights. And if this were not bad enough, where you're in a government where there is corruption, where there's a defect in holding civil government accountable, let's say there are no checks within government, and so you especially need negative rights, you especially need the rule of law for protection of rights and also for development, to encourage the economic development, let's say. Positive rights and its consequences actually support arbitrary power, the arbitrary power of the executive of civil government. In addition to what I've already pointed out, think of these factors as well. To embrace general positive rights impedes courts and legislatures from using rights to limit the executive by law. If there's a dilution of the meaning of rights and the rule of law, then you could pass in the legislature all rules establishing all sorts of rights and establishing all sorts of rules of law. But if rights and the rule of law themselves are compromised, how effective will that enterprise be? Embracing general positive human rights makes available cheap paper rights to show commitment, progress towards rights, in a context where delivery of these rights is not really expected and is easily dodged. And there's some evidence that documents that the more paper rights are supported, are adopted by governments, actually the less the ultimate ends of those rights is being supplied. The people are covering up the lack of the supply of food, the supply of clothing, by saying, well, we've adopted this right, see, we take these rights seriously, we have papered it, and we're making progress towards that. See how easy it is to cheat people of a system where they would get food, would get clothing, by saying, well, the government will take care of that. Look, it's in our Constitution, let's say. Third, to adopt these broad, positive human rights helps excuse violation of negative rights, sometimes called bourgeois rights. The right to property, let's say. Let's say all the human rights are in one big pile, let's say, and you're advancing, you claim positive rights, but you're ignoring negative rights. Let's say you're taking people's property in an unlawful way, violating negative rights. You could say, well, we're advancing some rights, and these rights are in necessary tension, so to advance positive rights, some rights have got to go. And you would excuse a violation of negative rights by saying, well, we are advancing human rights. Look at all these positive human rights towards which we're making progress. Dangerous. And that, in fact, that move has been made too. And similarly, governments have hidden behind positive rights to cover violations of the rule of law. And this is especially dangerous if a thick definition of the rule of law is adopted. Let's say there's a thick definition of the rule of law, a thick definition that embraces positive human rights, and let's say a civil government is denying the thin version of the rule of law. Again, they could say, well, we're making progress towards recognizing the rule of law. The rule of law requires that we supply these needs, fulfill positive rights. And again, sometimes the negative understanding of the rule of law must fall so that we can advance the rule of law in its grand understanding, pointing toward the positive human rights in the thick version. So I suggest to you that it appears that these grand positive human rights, they both threaten and menace negative human rights. They threaten the rule of law. They ultimately threaten inalienable rights. But not to worry, folks. Positive human rights are not really human rights in the first place. Thank you very much for your attention. Be glad to entertain. Glad to entertain questions or maybe discussion amongst yourselves, whatever the pleasure of the crowd is.
Burgoyne.
Mr. Burgoyne.
So your argument appears to be that as we increase...
This is going to be a longer question, so let me bring the mic to you. Instead of trying to repeat your question, Mr. Burgoyne.
As we proliferate positive rights, we begin to endanger negative rights. That's the argument.
One of them.
So we have the example of communism, Nazism, Italian fascism, various degrees of socialism, everything up to European social democracy, which the jury is out. All those preceding attempts at claiming universal economic rights have led to tyranny and the reduction of negative rights.
Yes.
That's what the track record shows.
It is. As a matter of fact, the USSR was the chief proponent of the covenant I read, the covenant for cultural, economic, and social rights. It was the USSR proposing that, pushing that as a counterfoil to the bourgeois negative rights that the free world endorsed. So we want our covenant. And it's part of the politics behind the Declaration, Universal Declaration of Human Rights is the same, with both blocs agreeing, you get your rights, we get our rights, and then they split it up for the covenant, and the USSR, again, the covenant we have never signed ourselves, was pushed by the USSR, especially other socialist countries, to say, we've got our own rights. Look at the progress we're making on these, to heck with your bourgeois rights that aren't really, how important is a right of liberty and property if you don't have any property at all? Right, and you can't exercise choices. That's the Marxist critique, and it was memorialized in that covenant that I read from. But even there, of course, they're derogable, qualified, contextualized. Mr.
Geyer?
Mr. Geyer, is this going to be a quickie?
A relatively quick question, I think. I want you to go back. Could you talk about how the Seventh Amendment, right to trial by jury, how that isn't a positive right? I'm on board with the bulk of the lecture, and I get the other rights you mentioned aren't, but how, I didn't quite get the logic where you said they have to provide you with X, but it's not because of the condition. I didn't quite follow.
Right. Well, adverting to the test, again, I propose, again, the question is clarification on Amendment 7, how that is best understood as a negative right, not just positive rights.
Yeah.
If the test for negative right is, if the civil government did not exist at all, would that negative right be fulfilled? That test is met here because our Amendment 7 says, in suits at common law, where the value and controversy shall exceed $20, the right of trial by jury shall be preserved. So if there's no government to conduct that suit, the suits aren't being conducted. The idea is, if we're going to subject someone as a defendant to a suit at common law, we will provide these rights. So, in other words, you can't subject them to that suit unless you provide these rights, so it ends up being a conditional negative right.
Okay, and so if you zap the government out of existence, obviously there are no trials and
exactly so.
Trial by jury goes.
Exactly. Same with Amendment 6 and all criminal prosecutions. If there were no criminal prosecutions at all, that would be fulfilled. So that's now some people differ from me on this, but I really have been convinced by commentators I've read who said it really is best understood as a conditional negative right. Because if the government didn't exist at all, then they're not subjecting you to that violation. Yep, Mr. Cameron, Professor Cameron.
You say the Ten Commandments are negative rights.
I don't think I did say that.
Well, do not covet, do not steal. Maybe this is what I was just privately thinking as you were saying. But it seems to me that they are negative rights. You say, shall not covet, thou shalt not steal, shall not kill.
Maybe. I'm not sure. Do I have a right not to be coveted against? I'm not sure that norm correlates with a right.
If I don't, if I, let's say steal, which makes it easier, thou shalt not steal. If I do nothing, I haven't taken your stuff.
Right, that stealing is good.
Okay, so.
Murder, killing is good. Bearing false witness is good. Yeah.
And coveting also, if I do nothing to take your stuff, so why does Christ then summarize it as saying to love your neighbor as yourself? I mean, it seems to me that he summarizes it as a positive right, as opposed to the Ten Commandments being a negative right. If you didn't mention the Ten Commandments, and that's purely what I was thinking.
No, it's good. That's good. Yeah, my answer would be that the the duty to love your neighbor as yourself subsumes not violating that person's rights. It goes beyond that. You're actually supplying, you're exercising the power positively to supply things to him. But at the very least, you're not taking stuff from him. So if it's a negative right, it's subsumed within love. I think love is the summary of the law, negative and positive moral duties. But the difficulty comes, again, with fulfilling positive moral duties in a way that John Paul II discussed. Does that do it, Professor Cameron?
Yeah, it certainly helps.
Yes, I'm sorry, Miss
Gebler.
Miss Gabler.
Quick question. Would you categorize the First Amendment also as a conditional negative right to the extent that we contextualize it in terms of whether it's a public concern, not a public concern, whether it's defamation or not defamation, and to that extent it is contextualized, while it would satisfy your negative test of not being an issue in the absence of government, it is a contextualized right.
Well, my reading of the First Amendment is different from, in all due respect, the reading of the Supreme Court. I think the First Amendment, when it says, let's say that you're talking about the freedom of the press, the freedom of speech, I think those are terms of art, and I think you go back to the English documents, the Bill of Rights, and the settlement with the House of Hanover, and it's pretty clear that the freedom of speech meant the freedom of parliamentarians to discuss in Parliament matters of state. And since Parliament is sovereign in Britain, the analogous body in our civil government is the citizenry. So the analogous privilege we have, the freedom of speech, applies to us. So I think the argument would be once you define the range of it, it's not as contextual as positive rights. I mean, even if you don't buy my pitch on that, which is a typical pitch, I think Alexander Michael-John proposed something like back in the 30s or 40s, you can still say that, again, negative rights, once they're defined, the reach is defined, they're susceptible to rules in a way that the contextualization of positive rights is not. Yes, Ernie?
Can you talk briefly about the difficulty of judicial enforcement of positive rights and actually how, when the judiciary tries to enforce positive rights, it turns law into politics?
Yeah, I think I just mentioned that, didn't I? Yeah, the idea would be the more that, and this is discussed by Roberto Unger, who's a critical legal studies scholar, who's discussed it at length. What happens when, instead of having pretty clear rules to be applied, you have courts trying to apply weighing factors and taking into account a multiplicity of competing interests? How much rule of law can be adhered to? And he suggests not. He suggests the more there are these multivalent weighing considerations, the more we're departing from what was understood to be the rule of law. I mean, Scalia wrote an article called something like "The Rule of Law is the Law of Rules," and rules are very hard to embrace all the contextualization required for positive human rights. So if you involve the courts in this matter, you're really turning the courts almost explicitly into organs of policy and not allowing them to serve as they once were, organs of law. Ernie, did you want to, you're giving me the thumbs up. I thought you were setting me up again.
Sir,
Yes,
are
Jeff.
there any examples, historical examples anywhere, because I think I heard you say this, I'm just wanting to make sure, where the rule of law was not eroded, and we mentioned the Soviet Union, we mentioned some others. Are there any cases anywhere so far where that wasn't the case, and if so, what was different?
I don't know the evidence on that. I'm sorry. I have my suspicions, and if you look at the paper that Ernie plugged, the human rights or the rule of law, the choice for East Africa, I do mention some studies, but to make a universal claim like that, I don't think I could do that. It's a great question. Great question. Yes, Miss Battenfield.
Would you characterize the right not to be discriminated by basis of gender identity a positive right? Because this summer I was in South Africa working with the ACHPR and also another organization, and we worked to try to keep out that phrase from a bunch of documents because it impinges on people's freedom of religion, freedom of speech, especially to preach the gospel, because if you preach the gospel, that could go against somebody's right to discrimination, freedom of discrimination based on their gender identity. So
Yeah. Embedded in your question is an interesting nuance that I didn't bring up, and that is, you could say the right not to be discriminated against on the basis of gender. It sounds like it's a negative right? You can't take from me a certain thing you'd otherwise give from me because by virtue of my gender. But for civil government to be involved in that, the civil government basically is trying to fulfill an obligation to police that. And that would require, let's say, positive remedies. You're making a claim of a positive right against civil government to remedy the violation of a negative right, which compounds it. If you think about it, negative rights all the time, enforcement of negative rights might involve a positive right that the government remediate it, that the government do make it good. And so that complicates the situation. But the plain question as to my right not to be discriminated against because, let's say, I'm a Jew or I'm short or I'm obnoxious, I would say that would be a negative right. Mr. Cohn.
Of the dangers and threats and menaces you've highlighted, in your opinion, which are, if any, are the United States in danger of?
Yeah, it's a great question. Mr. Combe asks, of the threats and menaces that I've detailed, which is the United States in danger of falling prey to? It's too bad that your mother is not here, because some have said that family law, let's say best interests of the child and other considerations unique to family law, do require this assessment of interests, this sort of multivalent work of the law, which might not be, there's prudence being exercised here, which might be inconsistent with a classic understanding of the rule of law, perhaps. And again, I have not studied to what degree we've compromised the rule of law. Again, Roberto Unger is the guy on this, even though he's a commie and a crit. I think he's nailed it. And there's some work also by Weber. My legal history victims have read this stuff. There's some literature, even starting in the 19th century, that anticipates the challenges to the rule of law. But again, I haven't done a careful study of just where we are. It's a great question. Ms. Dodge.
Is the United Nations a lost cause? Because I just can't imagine a shift in rights.
Yeah.
In the language you read from the Universal Declaration of Human Rights, is in all of the documents
Yeah.
coming out.
T.S. Eliot said there are no lost causes because there are no gain causes. Maybe that's the best answer here. Was it ever a cause that could be gained anyway? And again, I'm not a scholar of that. I just like T.S. Eliot a lot. Mr. Holland, we need the time. That's it.
Stop us briefly. It's 1 o'clock. If anyone needs to go, this is the time to do it. Before you do, I want to say one thing. Let's all give Professor Stern a round of applause.